In 1890, the United States passed its first federal law against monopoly. The Sherman Antitrust Act declared that every contract or combination in restraint of trade was illegal, and it did so in language so broad that lawyers would spend the next 2 decades arguing about what it actually meant. But here is the detail that the standard telling of this story leaves, sitting quietly in the margins. By the time that law was signed, the largest industrial monopoly in American history had already been standing for the better part of a decade. John Davison Rockefeller did not need to break the law to build it, because for most of the years he spent building it, the law he would eventually be accused of breaking simply did not exist. The record shows a company that had already claimed roughly 90% of the nation's oil refining capacity by 1880, a full 10 years before Congress got around to writing a statute that might have stopped it. So the question this story asks is not whether Rockefeller broke the law. The record is clear that for most of his ascent, there was no law to break. The question is what he built in that gap, how he built it, and what it cost the country to close that gap once it finally noticed what had grown inside it. There is also a second question sitting underneath the first, one that the standard classroom version of this history rarely lingers on. Once the law finally arrived, how long did it actually take to reach the thing it was written to stop? And what had already happened to the industry, and to the men who tried to compete against Rockefeller honestly, in the years it took for that law to grow teeth? If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. To understand how a single man came to own an entire industry, you have to start in Cleveland, Ohio, in 1863, a city that had no obvious claim to becoming the center of American oil. Rockefeller was 23 years old, a former produce clerk with a head for bookkeeping and a temperament that unsettled people who expected ambition to look excitable. He entered the oil refining business almost by accident, as a side investment alongside his produce commission firm, at a moment when petroleum was still treated by most investors as a speculative curiosity rather than an industrial foundation. The oil itself came from western Pennsylvania, where a boom that had started in 1859 had turned quiet farmland into a landscape of derricks, mud, and fortune seekers. Titusville and the towns strung along Oil Creek produced so much crude so quickly that the price of a barrel swung wildly from one month to the next, sometimes falling below the cost of the wooden barrel used to hold it. Speculators arrived by the thousands, threw up derricks on borrowed money, and vanished just as fast when a well ran dry or a glut collapsed the market. Refining, unlike drilling, required none of the luck of striking a well. It required capital, machinery, and the discipline to run a plant at a lower cost than everyone else running the same kind of plant down the street. Rockefeller understood this distinction before most of his competitors did, and he built his entire strategy around it. While other refiners treated petroleum as a boom trade to be ridden until it collapsed, Rockefeller treated it as a manufacturing problem to be solved with precision. By 1865, Rockefeller had bought out his partners in the produce business to focus entirely on refining, and by 1870 he had incorporated Standard Oil of Ohio with his brother William, his friend Henry Flagler, and a handful of other investors. The company that emerged from that incorporation controlled roughly 10% of American refining capacity, a substantial position but hardly a monopoly. What happened over the following 2 years is where the standard account of Rockefeller's rise tends to compress a great deal of complicated financial engineering into a single word, ruthlessness, when the more precise word is leverage. Rockefeller's first great structural advantage came not from refining technology but from freight. Oil had to move from the Pennsylvania fields to refineries and then to markets on the coast, and it moved almost entirely by rail. The railroads competing for that traffic, principally the Pennsylvania Railroad, the Erie, and the New York Central, were locked in a rate war that was destroying their margins, and they were desperate for a way to guarantee volume without triggering open price competition among themselves. In 1871, a group of refiners, including Rockefeller, organized a company called the South Improvement Company, and its charter, obtained quietly from the Pennsylvania legislature, gave it powers that had nothing to do with improving anything in the conventional sense. The arrangement it structured with the 3 major railroads guaranteed member refiners substantially reduced freight rates, while non-member refiners paid the full posted rate. More significantly, the agreement included a mechanism known as a drawback, under which the railroads would pay South Improvement Company members a rebate on every barrel shipped by their competitors as well as their own, effectively taxing rival refiners to subsidize Rockefeller's growing operation. When word of the scheme leaked in February of 1872, independent oil producers in Pennsylvania erupted in what became known as the Oil War, boycotting South Improvement members and pressuring the state legislature to revoke the charter, which it did within weeks. The public arrangement collapsed almost as quickly as it had been assembled, but the collapse of South Improvement Company did not undo what its brief existence had already made possible. In the months surrounding the scheme, Rockefeller moved with a speed that his competitors, still reeling from the scandal, could not match. Standard Oil acquired 22 of its 26 Cleveland competitors in a matter of weeks, a consolidation so swift and so complete that it became known among the refiners who lived through it as the Cleveland Massacre. Rockefeller did not present this to the men he approached as a hostile takeover. He offered them a choice: sell now, at a price he considered fair, or compete against a company that could already move oil more cheaply than they could, regardless of what happened to the South Improvement Company's charter. Most chose to sell, and many took payment not in cash but in shares of Standard Oil itself, a detail that mattered enormously later, because it meant that a portion of what Rockefeller was accused of stealing from his rivals was in fact wealth he had converted them into partners in. A handful of the men he approached refused outright, convinced they could outlast him, and several of those holdouts were still refining oil independently a decade later, though at a fraction of the volume they had once controlled. Rockefeller kept a private, almost devotional account of these years in later life, describing the consolidation not as conquest but as rescue, an argument that struck many of the men on the receiving end of it as difficult to square with the fact that the alternative he was rescuing them from was largely one of his own making. By 1879, Standard Oil controlled an estimated 90% of the refining capacity in the United States, and it had achieved this dominance almost entirely before the decade in which most Americans imagined the great trusts being built. The company was not yet the vertically integrated empire it would become, spanning pipelines, barrel manufacturing, and eventually its own fleet of tank cars, but its command of refining alone gave it a chokehold on the entire industry, because every barrel of crude oil pumped from the ground in Pennsylvania had to pass through a refinery before it became anything a consumer could burn in a lamp. Control the refining bottleneck, and you control the price paid to producers at one end and the price charged to consumers at the other, without ever having to touch a drilling rig yourself. The legal architecture that let this scale of concentration function without collapsing into an unmanageable sprawl of subsidiaries arrived in 1882 when Rockefeller's lawyer Samuel Dodd devised the instrument that would give the entire structure its name. Standard Oil and its affiliated companies, spread across multiple states with different and often restrictive corporate laws, were consolidated under a trust agreement in which shareholders in the various Standard Oil companies exchanged their stock for trust certificates, held by a board of 9 trustees, who then directed the operations of the entire network as a single enterprise. On paper, each state's Standard Oil company remained a nominally independent corporation, complying with the letter of laws that restricted one corporation from owning stock in another. In practice, 9 men in an office in New York controlled the entire operation, and the word trust, previously a fairly mundane legal term describing a fiduciary relationship, entered the American political vocabulary as a synonym for concentrated industrial power that had outrun the law's capacity to regulate it. The certificates themselves were traded much like ordinary stock, giving the arrangement the outward appearance of an unremarkable investment vehicle, while the trust agreement, buried in its clauses, gave the 9 trustees the authority to elect the directors of every subsidiary company, set production quotas, fix internal pricing between affiliated refineries, and reroute capital across state lines without consulting the shareholders of any individual company. Other industries noticed almost immediately. Within a few years, similar trusts had formed in sugar, whiskey, lead, and cottonseed oil, each one borrowing the same legal scaffolding Samuel Dodd had built for Rockefeller, and each one presenting state legislatures with the same underlying problem, a structure that satisfied the letter of corporate law while defeating its evident purpose. The public record of what this structure produced accumulated steadily through the 1880s, though it did not arrive all at once, and it did not arrive primarily through government investigation. It arrived through journalism and through the complaints of the independent producers and refiners who had been squeezed out or absorbed. Henry Demarest Lloyd, a journalist for the Chicago Tribune, published a lengthy exposé in the Atlantic Monthly in March of 1881 titled "The Story of a Great Monopoly," describing in granular detail how Standard Oil used its railroad relationships and its scale to crush competitors who had no comparable leverage. Lloyd's article did not name every mechanism with precision, because much of the internal machinery of the trust remained genuinely hidden from outside view, but it established in the public mind the basic shape of the argument that would eventually reach Congress, that a company controlling 90% of an essential industry was not a triumph of efficient management alone, but a structural threat to the market itself. Farmers, small merchants, and independent producers across the Midwest had been sending petitions to their state legislatures for years, complaining about railroad rates and industrial concentration, long before any court took up the specific question of Standard Oil, and by the early 1890s, that pressure had built into something legislatures could no longer set aside. State governments moved before the federal government did. Ohio's Attorney General filed suit against Standard Oil in 1890, arguing that the trust arrangement violated the state's laws against corporations holding stock in other corporations for the purpose of restraining competition. That suit dragged through the courts for 2 years, and in March of 1892 the Ohio Supreme Court ruled against Standard Oil, ordering the trust dissolved. Rockefeller's response to that ruling is itself part of the record that the standard telling of the antitrust story tends to underplay. Standard Oil did not simply comply and disperse. It reorganized. The Ohio Company was formally severed from the network, while operational control remained coordinated through an entity based in New Jersey, a state whose corporate law had recently been rewritten to explicitly permit holding companies, corporations formed for the specific purpose of owning stock in other corporations. What the Ohio courts had ordered dissolved on paper was reconstituted almost immediately in a jurisdiction that had, whether by coincidence or design, made itself hospitable to exactly the kind of structure the ruling was meant to eliminate. Ohio was not alone in trying and failing to slow the trust down. Texas sued Standard Oil's marketing affiliate in the 1890s and eventually barred it from doing business in the state altogether, a ban that lasted for years, and that the company worked around through independent-looking distributors who quietly answered to the same New York office. Missouri, Kansas, and Tennessee brought their own actions over the following decade, each one adding another layer to a public record of complaints that state courts, working with jurisdiction limited to their own borders, could document but never fully resolve, since a company organized across the entire country could always relocate the disputed function to a friendlier state faster than a single legislature could close the loophole. It was against this backdrop, a decade of state-level litigation producing rulings that the trusts absorbed and adapted around rather than rulings that actually broke anything apart, that the federal effort took shape. Senator John Sherman of Ohio, brother of the Civil War general, had been pushing legislation against trusts since the mid-1880s, driven partly by genuine conviction and partly by the political reality that farmers and small business owners in his home state were furious about railroad rates and industrial concentration in roughly equal measure. The act that bears his name passed the Senate by a vote of 51-1 in April of 1890 and was signed into law on the 2nd of July that same year. Its central provision was strikingly brief for a law meant to govern an economy as complex as America's had become. Every contract, combination, or conspiracy in restraint of trade among the states was declared illegal, and any person who monopolized or attempted to monopolize any part of that trade was guilty of a misdemeanor. The brevity was not an accident of careless drafting so much as a reflection of genuine uncertainty about what the law was supposed to prohibit in practice, and that uncertainty proved costly in the years immediately following passage. The Department of Justice brought remarkably few cases against industrial trusts in the 1890s, and the Supreme Court's first major test of the law, the 1895 case against the American Sugar Refining Company, produced a ruling so narrow that it seemed to gut the statute before it had really been used. The court held that manufacturing itself, even manufacturing that controlled 98% of an entire product category, was not commerce in the constitutional sense, the act regulated, and that only the interstate transportation and sale of goods, not their production, fell within its reach. For the better part of a decade, the Sherman Act existed on the books as a stated principle, with almost no practical enforcement mechanism behind it, and Standard Oil, already reorganized under its New Jersey holding company structure, continued to expand. What eventually forced the issue was not a prosecutor, but a writer, and the specificity of her research changed what the public and, in time, the courts were willing to accept as established fact rather than allegation. Ida Tarbell had grown up in the Pennsylvania oil region, the daughter of a barrel maker whose business had been devastated by the very rate structures Standard Oil had engineered 2 decades earlier. Working for McClure's magazine, she spent nearly 5 years compiling a systematic history of the company, drawing on court records, congressional testimony, and interviews with former Standard Oil executives who had never before spoken publicly. Her series, published across 19 issues between November of 1902 and October of 1904, before being collected into a 2-volume book, did something no previous exposé had managed. It did not merely assert that Standard Oil was too large, it documented, with named individuals, specific rebate structures, and reconstructed internal correspondence, exactly how the company had used its railroad leverage to starve independent refiners of affordable transportation, decade after decade, long after the South Improvement Company scandal had supposedly ended that practice. Tarbell interviewed Henry Rogers, one of Standard Oil's own senior executives, over a period of years, a relationship the company only later realized had produced one of the most damaging sources in the entire series. She traced individual freight bills, cross-referenced them against railroad commission filings, and showed with a bookkeeper's patience how a barrel of independent oil could arrive at a refinery costing more to ship than the same barrel shipped by Standard Oil itself, even when the two barrels traveled the identical route on the identical train. Tarbell's history landed at a moment when the political climate had shifted enough to make use of it. Theodore Roosevelt, who had become president in 1901 following William McKinley's assassination, had already begun using the Sherman Act more aggressively than his predecessors, breaking up the Northern Securities Railroad Combination in 1904, in a case the Supreme Court upheld the following year. Roosevelt had built a public reputation as a trust buster largely on the strength of the Northern Securities case, and the political appetite that victory created gave his administration room to pursue targets that earlier presidents, wary of the financial disruption a major suit might cause, had left alone. The Bureau of Corporations, established in 1903 specifically to give the federal government investigative capacity it had never possessed before, spent nearly 3 years compiling its own report on Standard Oil's pipeline practices and pricing, independent of anything Tarbell had already published, and the two investigations, one journalistic and one governmental, arrived at strikingly similar conclusions about how the company operated. In 1906, with both the public record and the government's own internal findings pointing the same direction, the Department of Justice filed suit against the company under the Sherman Act, seeking its dissolution. The case took 5 years to resolve, moving through a federal circuit court that ruled against Standard Oil in 1909, before reaching the Supreme Court, which issued its decision on the 15th of May 1911. The ruling ordered Standard Oil of New Jersey dissolved into 34 separate companies, distributed to shareholders in proportion to their existing holdings in the parent trust. The court's reasoning introduced what became known as the rule of reason, holding that not every combination in restraint of trade was automatically illegal under the Sherman Act, only those that unreasonably restrained trade, a standard that gave judges considerably more interpretive latitude than the statute's original blunt language had suggested, and one that antitrust lawyers have argued over ever since. Justice John Marshall Harlan, writing in partial dissent, warned that this new standard handed the courts a discretion Congress had never granted them, and that future judges sympathetic to a given combination would always be able to find a reason to call it reasonable. His warning proved prescient. Within a generation, the rule of reason had become the dominant framework through which nearly every antitrust case in the country was decided, and the plain language of the 1890 statute, the language that had declared every restraint of trade illegal without qualification, receded into something closer to a historical curiosity than an operative legal text. What the ruling did not do, and what the standard telling of this story often omits, is punish Rockefeller in any financial sense that a casual observer would recognize as punishment. Rockefeller personally held roughly a quarter of the shares in the dissolved trust, and those shares were simply exchanged for proportional shares in each of the 34 successor companies. Within a decade, the combined market value of those 34 companies, no longer burdened by the political liability of operating as a single visible monopoly, and now free to be valued individually by investors who could see each one's specific assets clearly, had risen substantially above what the unified trust had been worth at the moment of its breakup. Some financial historians have estimated that the dissolution made Rockefeller, already the wealthiest man in the country, considerably wealthier still, simply by unlocking value that the trust's opacity had obscured from the market. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. The successor companies carried the state names their original incorporations had used before the New Jersey consolidation folded them together. Standard Oil of New York became Mobil, and the two would recombine under a single roof in 1999 as ExxonMobil, a reunification that occurred entirely within the bounds of antitrust law as it had come to be interpreted by the end of the 20th century, nearly 90 years after the Supreme Court had ordered their separation. Standard Oil of California became Chevron. Standard Oil of Indiana became Amoco, which BP acquired in 1998. Standard Oil of Ohio, the company whose dissolution Ohio's courts had originally ordered in 1892, was eventually absorbed into BP as well. The lineage of companies competing in global energy markets today traces back through these 34 fragments to the 9 trustees who sat in a New York office in the 1880s, directing an enterprise that state law had explicitly tried to prohibit and that federal law had not yet been written to address. Standard Oil of Kentucky, one of the smaller fragments, was reabsorbed by Chevron decades after the split, a quiet reversal of the very dissolution the Supreme Court had ordered, achieved through ordinary merger law rather than anything resembling the trust structure Samuel Dodd had once devised, but arriving at a strikingly similar destination all the same. What the record actually shows, when the sequence of events is laid out in order rather than compressed into the shorthand version most people carry, is a monopoly that was substantially complete before the legal tools to challenge it existed, that survived its first major legal defeat by relocating its corporate shell to a state that had rewritten its laws to accommodate exactly this kind of structure, and that was ultimately broken apart not because a law finally caught up with the harm the company was causing in real time, but because a decade of documented journalism made the historical pattern of that harm impossible for courts and regulators to keep treating as speculation. The dissolution itself, whatever its symbolic importance as the first great victory of American antitrust enforcement, left the man at the center of the structure wealthier than he had been before the government intervened. Rockefeller lived another 26 years after the ruling, long enough to become the country's first billionaire, a milestone he crossed around 1916, according to the estimates of his own financial advisors, and to give away roughly half of his fortune through the philanthropic foundations that still bear his family's name. The Rockefeller Foundation, chartered in 1913, funded public health campaigns against hookworm and yellow fever, underwrote medical schools, and helped establish research institutions that still operate today. The timing of that philanthropic turn, arriving in the years immediately following the dissolution suit, was not lost on contemporaries, some of whom viewed it as a genuine late-life reckoning with the methods that had built the fortune, and others who viewed it as the oldest trick available to a man whose name had become a byword for monopoly, the conversion of criticized wealth into celebrated generosity. Both readings can be true at once, and the foundations continue to fund medical research, education, and public health initiatives around the world, using capital that traces directly back to the refining margins Standard Oil extracted from railroads that had agreed, in 1872, to tax his competitors on his behalf. The Sherman Act itself did not disappear into irrelevance after 1890, but its early history complicates the story most people are taught about it, the story in which a law was passed and a monopoly was accordingly stopped. The gap between those two events ran nearly 21 years, and inside that gap sat the entire second half of Rockefeller's consolidation of the American oil industry, the New Jersey reincorporation that absorbed an adverse state court ruling without missing a beat, and the 5 years of federal litigation that ultimately relied less on the statute's original text than on a judicially invented standard, the rule of reason, that gave the courts room to decide which combinations counted as unreasonable and which did not. The law existed on paper from 1890 onward. Its practical shape, the shape that determined what a company the size of Standard Oil could and could not do, was not settled until 1911, and even then it was settled in a way that preserved the wealth of the man the law was ostensibly written to restrain. There is a pattern worth naming plainly, because it recurs across the history of American industrial concentration in ways that extend well past oil. The capital, and the structure to dominate a market, tend to arrive well before the legal framework capable of recognizing that domination as a problem. Rockefeller built his advantage through freight rebates negotiated in the early 1870s, consolidated it through a trust structure devised in 1882, specifically to route around existing corporate law, and preserved it through a New Jersey reincorporation in the early 1890s that anticipated regulatory pressure and adapted to it before that pressure fully arrived. Each of these moves was, at the moment it occurred, either explicitly legal or operating in a genuine gray area that no statute had yet addressed. The law that eventually named the behavior a crime was written after the behavior had already produced its principal results, and even that law took another 2 decades of litigation, journalism, and shifting political will before it was applied with enough force to alter the structure it targeted. The men who lost their refineries in the Cleveland Massacre of 1872 did not live to see the 1911 ruling vindicate their original complaints, and the independent Pennsylvania producers who financed the oil war boycotts against the South Improvement Company had, by the time the Supreme Court finally acted, mostly sold out, retired, or died waiting for a remedy the legal system was not yet equipped to provide. What the Standard Oil story leaves behind, beyond the 4 companies still operating today under names that trace to 1911, is a template for how concentrated industrial power in America has repeatedly outpaced the legal vocabulary meant to describe and constrain it. The refining bottleneck Rockefeller controlled in the 1870s has its analogs in later decades, in railroads, in steel, in telecommunications, and in the platforms and infrastructure that dominate commerce today, each generation of concentration arriving in a form specific enough to its own industry that the previous generation's antitrust doctrine has to be stretched, reinterpreted, or rewritten to reach it at all. The Sherman Act's rule of reason, improvised by the Supreme Court in 1911 to decide what to do about a company that had already won, remains the operating standard American courts apply to monopoly cases more than a century later. Federal antitrust suits filed against technology companies in the early 21st century cited the Standard Oil case directly, arguing over how much a rule built for railroads and barrels of kerosene could be stretched to cover markets that did not exist when the rule was written. In each of those later cases, as in the original one, the pattern held. The dominant position was built first, in a regulatory environment that had not yet caught up with the specific mechanics of the industry in question, and the legal reckoning, when it came, arrived years after the position was already secure. The oil that came out of the ground in Pennsylvania in the 1860s has long since been refined, sold, and burned. But the corporate architecture built to control its passage from well to market outlived the substance itself by well over a century. Standard Oil's 34 fragments merged, split, and remerged across the 20th century into a handful of the largest companies in the world, still recognizable by name to anyone who has ever stopped at an Exxon or a Chevron station, still carrying, several corporate generations removed, the residue of decisions made in railroad offices and legislative chambers before antitrust law had a name. The law that was supposed to prevent one man from owning an entire industry arrived after that industry had already been owned, and the record of how it arrived, who delayed it, and who profited in the gap between the monopoly's construction and the law's arrival remains available to anyone willing to read the court filings, the congressional testimony, and the 5 years of magazine issues that a barrel maker's daughter from the Pennsylvania oil fields spent compiling into the most complete account of how it happened. Thank you so much for watching until the end. If you loved this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.